Hi. In this month's vlog, we're going to have a discussion about a topic that catches a lot of people by surprise, our clients, I mean. And that's the concept of causation and reasonable and necessary nature of medical care in a personal injury claim. If somebody were to hit you and it's clearly their fault and that's not anything that's being disputed, I think most people assume that the care that they go and get to treat any injury that they may have incurred would be a no-brainer and automatically paid for. Unfortunately, that is very far from the truth and the reality in these cases. What the law in Washington and in most jurisdictions is that the person who is injured must prove first, of course, that the accident was somebody else's fault, but then that it was the accident that caused the injuries, and also that the care that the person then received for the injuries was both reasonable and necessary to treat those injuries. On the surface, that may seem, again, like a no-brainer, but what those two, because those two areas of dispute must be individually proven, that means that the other side and the insurance company representing that driver is going to make efforts to stop you from effectively proving that. Causation can be disputed if you had a prior injury to the same area of the body, if you have a subsequent injury or incident that even though you claim it didn't injure you, they may claim that it did. Reasonableness and necessity of medical care, all they have to do is hire a doctor to come in and say that they don't believe that this care or that care that you received was reasonable or was necessary. You would have gotten better whether you'd had it or not. And there are, maybe again surprisingly, maybe not, a whole host of medical professionals who are perfectly willing to come in and do that day after day, month after month in a courtroom and say that, people weren't hurt. Sure, it was this person's fault, but we don't think you were hurt at all. And if you were hurt, then the injury that you had wasn't caused by this. It must have been, just due to your age, maybe due to your job, maybe due to anything other than this particular accident. And then the care that you got, well, you didn't need that anyway, and your doctors never should have put you in for this test or that test. So because the law allows the offending party to dispute, and because the standard is reasonable and necessary, well, that's a very subjective thing that people can differ in opinions of. That means that it can be very hard work and very difficult work to sometimes connect all of the dots and to get our clients from being injured to receiving a fair recovery for what they've been through. I hope that sheds a little bit of light on that particular topic. If you have any questions, concerns, our consultations at Wiener and Lamke are always free, and we're more than happy to talk with you and see if hiring an attorney is something that you may need for your personal injury matter. Thanks so much.